Good afternoon and welcome everyone to today's edition of the EPIP webinar. We've actually partnered with Public Allies to bring this webinar to you. It's Crowdfunding 101. This is our 11th EPIP webinar of the 2014 year, and actually our third in this joint series with Public Allies. I am your EPIP host for the afternoon. My name is Michael Barham. Our speakers are Robert Esposito and Shawn Pelsinger. Those of you who joined us for Social Impact Bonds 101 and 102 know them very, very well. They are fantastic teachers, and they are NYU Law and Social Enterprise Fellows. So we're going to do a lot of learning today, but before we get to that, I want to tell you all a little bit about EPIP and Public Allies if you are not familiar with our organizations. So, Emerging Practitioners in Philanthropy is a national network of foundation professionals and social entrepreneurs who strive for excellence in the practice of philanthropy. We're not just a network, we try and provide a platform for our community to connect with others, learn and practice leadership skills, and voice more emerging transformative thoughts in the social sector. If you are not yet an EPIP member, we'd encourage you to join. We have a lot of programs just like this coming up for the second half of 2014, and I'm always happy to discuss our network, our platform, and our programs in more detail. So please feel free to reach out to me, Michael, at epip.org. As I said, we're joined today by Public Allies, and our good, dear friend, MacArthur Antigua, is here to tell you a little bit about what they do.
Right on. Thanks so much, Michael. And wanted to say hello to the Public Allies alum on the call. Just want to do a quick spot. I'll plug Public Allies. Our mission is advancing leadership to strengthen communities, nonprofits, and civic participation. Our main engine for that has been our AmeriCorps apprenticeship, which is now currently run in 23 cities across this country, and we just finished with about 580 folks finishing it. You know, the angle I come from it is I work with our alumni. There's been 5,500 alumni that have gone through this transformative experience. 80% still work in the public sector. And so our charge is to continue to advance the leadership practice. That's the skills career network of those people, as well as their impact. Find ways to get the gang back together, if you will. And so, and it's also great to find allies, if you will, lowercase allies like emerging practitioners in philanthropy, as we've learned that there's a significant amount of our alums who are interested in the funding of social change, and that's how we came up with this joint, which has been this really cool 4-part series with our colleagues from New York University. So, if you want to learn more Public Allies, hit me up at, I'm sure my address will be there somewhere. I'll be back on session 4. But in the meantime, Michael, it's been great being with you on this journey so far.
Thank you so much, Mac. And yes, this is the third in the 4-part series, so we have one more coming to you. The date is to be determined, but we'll be sure to get that information out when everything's been settled. So, folks, please keep a lookout for that. And thanks again, Mac. All right, folks, a couple of other quick announcements before we get things started. EPIP People of Color Network Gathering at Facing Race Conference is coming up in November. There's more information available on our website, epip.org/PCN, but it's taking place in Dallas, Texas at Race Forward's Facing Race Conference, November 13th to 15th. Keep a lookout for more information. We'll have an email blast going out later. We also have taken the month of August off, but we have a webinar coming up September 10th with the actual founder of EPIP, Rusty Stahl. We're going to be talking about strengthening talent in using philanthropy to strengthen talent in the nonprofit sector. So that should be really interesting. We'll have a few funders joining us as well to tell us about some of the programs they're working on. So keep a lookout for more info on that. But that's going to be a great one to kind of kick off the fall when everyone's back after Labor Day. And as always, check out epip.org/events for any upcoming events. Couple of other items for housekeeping. For those of you calling in on the phone, please make sure to mute your computer so we can avoid an echo. all attendees will be kept on mute. So if you do have questions, you have any technical difficulties, use the question box, and we'll keep an eye on that. If there are any issues, we'll try and resolve them as the webinar moves along. And feel free to submit questions for panelists throughout. We'll be reserving about 10 minutes at the end of the session for Q&A, and we've gotten some really interesting questions in these past webinars with Shawn and Robert. So I know we're all learning a lot rather quickly, and we pack a lot of content into that. So please feel free to submit questions throughout. And for those of you who may have to hop off early, the webinar will be recorded and available on the EPIP website within a week or so. If you have any questions about that, feel free to reach out to me. And please complete the post-webinar survey. We continually want to get better and improve our program, so it's always good to hear from attendees and learn ways we can improve. So a little bit about today's speakers. Robert and Shawn have been fantastic working with us so far. They are both Jacobson Fellows in Law and Social Enterprise at NYU. Rob also received his bachelor's from Dartmouth and JD from Wake Forest University. Shawn also graduated from NYU Law, and prior to rejoining NYU was a corporate lawyer at Sherman and Sterling. And I know Shawn and Rob are always eager to get started, so without further ado, gentlemen, I'm going to toss it over to you.
Hello? All right. I think we are live. Let me pull this.
We can hear you both, and I think momentarily, yes, we can see your screen as well. Fantastic.
Okay. Hello, everybody. I'm Shawn Pelsinger. I'm here with Robert Esposito. Before we get underway, something that we keep forgetting to mention is that this is not actually legal advice. This is hopefully an informative seminar, but nothing that we say here should be taken to be legal advice or establish a legal relationship, and we just need to get that out of the way so that we don't get in trouble on our end. As I think was mentioned, we'll be doing a 10 to 15 minute Q&A at the end. Feel free to submit questions throughout. And if anything, I'm not sure who's going to be overseeing the questions as they come in, but if anything comes up that seems like it's pressing or particularly relevant or is asked by a number of people, feel free to just jump in and interrupt. It's better to handle things while we're dealing with them if questions are, keep coming up, the same question over and over. Anyway, this is Crowdfunding 101. We're going to be discussing a number of different types of crowdfunding, and here's our overview. We're going to go through a general survey of crowdfunding, break down the types, and then we're going to dig a little bit more deeply into equity crowdfunding at both the federal and the state level, including the Jobs Act. And then we're just going to briefly touch on what we see as maybe some natural outgrowths of crowdfunding and social enterprise. We weren't sure whether or not people wanted to hear strictly about equity crowdfunding or about some of the other older forms of crowdfunding, and even some of the ones that are not yet being regulated as heavily as equity crowdfunding. So we're just going to cover what we consider to be the 4 subdivisions of crowdfunding. Let's just kick off with a couple of quotes on what is crowdfunding, and I'll read these. A practice of funding a project or venture by raising many small amounts of money from a large number of people, typically via the internet. We just looked around at a number of different articles and resources to find what we thought were 2 of the more accurate descriptions. Here we have also the use of small amounts of capital from a large number of individuals to finance a new business venture. Crowdfunding makes use of the easy accessibility of vast networks of friends, families, and colleagues through social media websites like Facebook, Twitter, and LinkedIn to get the word out about new business and attract investors. It has the potential to increase entrepreneurship by expanding the pool of investors from whom funds can be raised beyond the traditional circle of owners, relatives, and venture capitalists. And we think that pretty accurately sums up the world of crowdfunding, which is basically the more accessible pools of capital that are tied to your existing networks or simply a bit more accessible by virtue of the internet. And crowdfunding, as you can see on the bottom, has really taken off recently. We have growth from 2010 at $89 million raised via crowdfunding, all the way up to what was projected to be $5.1 billion. We weren't able to find solidified figures, but Rob is signaling to me that the figures he's seen actually come in higher than $5.1 billion for 2013. And I think we've seen almost double that for 2014 projected. So crowdfunding has really, really taken off, I think, in a way that, I mean, especially between 2010 and 2011, in a way that I don't think people really predicted at all. Eric, go ahead. Yeah? No? There we go.
Before we get into the types of crowdfunding that Shawn is going to run through, I think it's also important to note as we start and kick off this conversation that crowdfunding is really an outgrowth of the microfinance industry, and I'm sure some of our audience members are familiar with the work of Muhammad Yunus, who won a Nobel Peace Prize in 2006 for his work, essentially as the grandfather of microfinance and microcredit. His Grameen Bank and affiliated organizations have sort of championed that cause and have really seen some considerable success in the developing world in being able to loan small amounts of money to rural areas in the developing world, and have seen very, very high return rates on those loans. They pay out, I think it's something over 95% of the time, which is quite good. So there's not a lot of defaulting, and the resulting access to capital raises the standard of living considerably, in addition to fostering education and human rights around the world. So the notion of crowdfunding really builds on the success of the microfinance sector, and they share a similarly democratic view of investing, i.e. getting access to capital across very large swaths of the population that otherwise would not have access to it. And so I just think it's important to mention that before we jump into the types of crowdfunding that Shawn is going to just briefly run through right now on this slide.
Thank you. So it's a good background to start off with microfinance and its history and contributing to the growth of crowdfunding, and jump right into debt, which we have as the first of the 4 types of crowdfunding, because microfinance has traditionally been carried out via debt, or just lending as between individuals in one part of the world and individuals in another part of the world. And so debt crowdfunding is effectively where investors make loans to people and are repaid over time at a negotiated interest rate, which is sometimes, depending on the entity, no interest rate at all. An example of that is Kiva, and we're going to get into Kiva in a bit. Equity crowdfunding is the sort of crowdfunding that's regulated under the Jobs Act. Here's a situation where investors receive some sort of security interest, either shares in a company, units in an LLC. An example of a platform that facilitates equity crowdfunding is Seed Invest, although there are many, many popular ones now, dozens that are springing up every couple of weeks. Donation-based crowdfunding is one wherein a contributor makes a financial donation with no expectation of repayment or consideration. It's what we see as ubiquitous or distributed charitable contribution. And then rewards-based crowdfunding is the kind of crowdfunding where what you get in exchange is a service or a tangible product. And this is the Kickstarter and Indiegogo and that whole category of companies. Effectively, the investor purchases something. Usually it's time deferred while the company goes into production, but it's in exchange for some sort of product or service. And those are the broad categories of crowdfunding. Here you can see this is the average campaign target size. So the smallest is a donation. Charitable contributions or requests for charitable contributions average about $664 in their campaigns, and they account for nearly half of all crowdfunding. Next would be rewards-based. The Kickstarter campaigns target on average $4,000 per campaign and are a little over 1/10 of all crowdfunding. Then comes the Kiva-style loans. 5,500 is their target, and then more than 10 times the size of the next largest category is equity. Equity crowdfunding is a little less than 1 in every 5 campaigns and makes up, on average, at $85,000 per campaign target. And this is one of the reasons that we're going to see a lot of regulation hovering around the equity crowdfunding world, because it's dramatically more expensive. There's more money at stake. There's more money to be lost. And this is also one of the reasons that there's an interesting interplay between the state and the federal regulation of these two. And you might actually argue that the states that control regulation of donation-based crowdfunding do so because for a number of reasons, one of which is that the stakes are a lot lower there on average versus in the equity crowdfunding game. The threat is that crowdfunding is going to potentially compete with much, much larger federally regulated private placements. So from there, we're going to move on to a deeper dive into debt. You want to do this? I can do it. All right. So we've got debt highlighting Kiva here. So debt crowdfunding is most commonly peer-to-peer, and Kiva is worth highlighting because it's really the largest and most successful of the debt crowdfunding platforms. Launched in 2005, Kiva provides for a minimum of $25 loan, and they issued $322 million in loans between 2005 and now. It's been incredibly successful, having over 870,000 users, over 470,000 loans issued, and a pretty impressive 98.98% repayment rate. So here, lenders receive only their principal back. They don't actually make a profit. There is no interest rate in Kiva loans. And this is one of the ways that Kiva has avoided more serious scrutiny and regulation, the sort that is now coming up under the Jobs Act. And that was not always the case. Back in 2008, Prosper, Loanio, and Lending Club were all the subject of SEC enforcement actions or cease and desist letters, actually, when the SEC claimed that effectively these companies were selling securities. They were selling loan participations that resulted in some sort of payback involving an interest rate, and it prompted the SEC to go back and re-examine one very old securities case that the Supreme Court had decided, and a more recent case back from 1990, Reeves v. Ernst & Young, where the Supreme Court carved out what exactly was a note versus what was accepted from the definition of security, but was also a note or debt instrument. And there's a laundry list of exceptions below, but the idea was that Kiva has been able to avoid being caught by this securities regulation regime because it doesn't charge any interest on its loans. Prosper, Loanio, and Lending Club have all been forced to adapt. The most prominent adaptation would be that they limit the folks who can invest in these loans, if they want to turn a profit, to accredited investors. And accredited investors, for those of you who aren't familiar, it's a level of financial sophistication that the SEC chooses as a sort of a benchmark to determine whether or not you can participate in private capital raising and private capital investing. And that, we're going to move on to donation-based crowdfunding.
Right. So this is the second type of crowdfunding that we're going to talk about today. It might be of particular interest for this audience. Unlike the crowdfunding Shawn discussed earlier, donation-based crowdfunding, or actually similarly, it does not involve any return on the investment or any consideration. These are charitable donations that are simply made online via these portals. They therefore fall subject to the same charitable solicitation regulations that any normal, print, email, mail campaign would. They are the most widely visible of the crowdfunding categories. You can think of some very popular examples like Wikipedia, Red Cross, many political campaigns operate exclusively through donation-based crowdfunding. And as we discussed on an earlier slide, it accounts for just about half of all crowdfunded dollars out there, which is a considerable amount, given that we have now reached the $5 billion barrier. Now, obviously, that stands in a stark contrast to the $300 billion a year that charities take in through charitable donations in the United States. However, we and many others believe that the percentage of donations that are crowdfunded will continue to grow, particularly as these crowdfunding platforms solidify their space in this emerging online sector. Here's one notable example is a local Chicago organizer who initially raised about $140 million to fund an unlikely political campaign, ended up becoming the President of the United States, and raised money from over 1 million people via the Obama campaign's website. So there is considerable room for success in this space. I'm going to talk a little bit about some of the legal considerations that go into donation crowdfunding from a charity and nonprofit perspective. The first and most obvious is the charitable solicitation regulation. About 44 states have some form of charitable solicitation act on the books. Very broadly speaking, these acts require that charities register with each state in which they solicit funds, and that they report financially at the end of their financial year to generally the Attorney General, who has the authority to regulate charities in most states. Notably, these regulations are not triggered by the receipt of funds. They are actually triggered by requesting a donation in the first place. And so this means that charities must ensure that they comply with these statutes before they ask for any money, not after they've received it. The big question from a legal perspective with donation crowdfunding is, does it actually trigger the registration and reporting requirements under these acts? And this is a question that is still very much up in the air. I would note that the Charleston principles have something to say about this. The Charleston principles are about 10 years old now. They were originally devised to deal with online donations. These principles were written before crowdfunding took off, before it even existed, frankly, and they generally deal with charities that own and operate their own personal websites that take donations in through those websites, not through crowdfunding portals. But some attorneys have speculated that the Charleston principles apply with equal force to crowdfunding portals like Kickstarter and Indiegogo. Under the Charleston principles, when you are soliciting through an interactive website, and you are either specifically targeting persons in a given state or receiving contributions from a state on a repeated and ongoing basis or a substantial basis, the Charleston principles say that either of those circumstances require the charity to register under the Charitable Solicitation Act. I would note that these are not legally binding in any state. They are guidelines that have been promulgated by an organization of attorneys general, and they have not yet been adopted by any state legislature. That is not to say that state attorneys general are not paying attention to the crowdfunding space. In fact, recently, the Washington State Attorney General Bob Ferguson filed one of the first consumer action lawsuits in a crowdfunding situation. This situation dealt with a project for horror-themed decks of playing cards the consumers did not get those decks of cards that were promised to them through this Kickstarter campaign, and the Washington AG filed suit against the project, and eventually, I think, prevailed on that. So increasingly, state attorneys general are getting very much involved in this space. They are aware of this space, and they are going to increasingly look to the Charleston Principles for guidance on how to deal with these types of situations. Leaving the Charleston Principles aside, and say you are not specifically targeting anyone within a given state, and you are not receiving repeated and ongoing contributions from a particular state, it is very often the case that charities will follow up with donors in a month, 6 months, or so after they've made their donation and request additional donations. These follow-up communications would be regarded by many charitable solicitation acts to be specifically targeting persons within a state. So if you are a charity in New York and you set up a Kickstarter campaign for your charity and you receive donations from 99 people in New York and 1 person in California, then you send follow-up communications to all 100 people. That follow-up communication would require you to register in California as well as New York. So that's something that a lot of charities using crowdfunding to obtain donations should be very aware of as they wade through these waters. The other big concern has to do with commercial fundraisers. These are persons or organizations that are paid by a nonprofit to raise money on the nonprofit's behalf. And I'm sure that there are many audience members that are familiar with these organizations. There is a legal question as to whether crowdfunding platforms constitute commercial fundraisers. There are registration requirements in many states for the commercial fundraisers, and there are also rules against engaging with non-registered commercial fundraisers. And so charities need to be especially vigilant here with regards to who is doing the soliciting. Is Kickstarter doing the soliciting, or are you doing the soliciting? And who is receiving and controlling the funds that are donated? I have seen a few analysis of Kickstarter and Indiegogo. It appears to me that they do not fall under the definition of commercial fundraisers. Nevertheless, there are many platforms for crowdfunding that are available to nonprofits and charities, and the same cannot be said for all of these options across the board. So if you are going to use this as a method of obtaining donations, it's important to know how the solicitation is occurring and who is controlling the funds. And finally, there is just basic fraud and misrepresentation. It's very important for charities that are conducting crowdfunding campaigns to specify precisely what they are asking for and what cause or charitable purpose the monies will be used for. Charities also need to be aware of the potential for unauthorized or fraudulent crowdfunding using their name, perhaps not even to their knowledge. To sort of protect against that, charities should be adopting some sort of general gift acceptance policy for crowdfunded donations to avoid running into problems with unauthorized or fraudulent crowdfunding activities. One potential option that Indiegogo offers is the Verified Nonprofit Campaign Badge, which you can see on the next slide, and it's the highlighted area on the bottom right there. That is one vehicle to protect against unauthorized or fraudulent crowdfunding, and also adds a little bit of certainty to a donor, from a donor's perspective, that this is a legit nonprofit crowdfunded campaign. Shawn is going to talk a little bit about reward crowdfunding.
All right, thank you, Rob. So reward crowdfunding is probably what people see most on the internet and in the press. It's the Indiegogo and Kickstarter style crowdfunding, and I guess we should distinguish what Rob just covered, that is donation-based crowdfunding that happens to take place on Indiegogo and Kickstarter that goes towards a charity of some kind and doesn't result in any sort of tangible product at the end that is sent back or that is able to be viewed by or enjoyed in some way by the consumer or by the donee. What I'm talking about here is basically the purchase of a product or service, and as we see here, often in the development phase with delivery likely to be deferred for a number of months. That's the standard Kickstarter and Indiegogo campaign process. And this is, although the smallest of the, I want to say it makes up the smallest of the assets that are devoted to crowdfunding, it is probably the one that gets the most attention right now. Some notable raises here: the Pebble watch that raised $10 million, exceeding its $100,000 goal, spread across 66,000 people. The Veronica Mars movie, which hit about $2 million in crowdfunding across 45,000 backers, and I think did that within a day or two of launching, something with I mean, you can see there's still 29 days to spare here when they cross the finish line. And the Oculus Rift, which raised $2.4 million from almost 10,000 backers. And these were all situations they're aberrant in that they were incredibly popular and that they exceeded their goals by a long shot, but they really capture the sorts of projects that are common of rewards-based crowdfunding, which is you get a product or access to a movie or publication or some piece of work by an artist, or some sort of tech device. And this is basically what we've come to know as crowdfunding more commonly. And so what's interesting here is, and I think this has been some of the basis for a lot of the rumblings in the crowdfunding world, is eventually Oculus was purchased by Facebook for $2 billion, and a lot of people started to think, well, I donated $300 or I invested $300 in exchange for an Oculus Rift. What would I have gotten instead if I were a venture capitalist and I'd given them the same amount of money? I think there's an extra zero here that shouldn't be 435,000. But if you had invested $300 in Oculus Rift when it was running its Kickstarter campaign and you had received shares in the company instead of a device, you would have come back with shares worth about $43,500. And here we see some quotes: "I backed Oculus Rift and all I got was this lousy T-shirt," or "I would rather have bought a few shares of Oculus rather than my now worthless $300 obsolete VR headset." So I think a lot of this sentiment was, paired with the real prominence of the venture capital world and tech startups right now, had built towards the idea that maybe average individuals should be allowed to do just that, should be allowed to purchase shares in Oculus Rift rather than backing them in exchange for a physical device that is less risky because the device is going to be delivered to you. So that gave rise to what we now know as equity crowdfunding. And here are a couple of examples of equity crowdfunding companies. There are many, many of them out there. But the quick definition: equity crowdfunding is the widely distributed sale of equity securities via an online portal. It is what many people are talking about when they refer to the growth of crowdfunding, or to the emerging world of crowdfunding, or the about to be regulated world of crowdfunding. A 2013 survey found that the average equity crowdfunded raise was around $178,000. This is not the target size that we've referenced for. This is what the actual raises turned out to be. And AngelList, Seed Invest, Circle Up, these are some of the more well-known equity crowdfunding platforms. Here's Seed Invest homepage, where they advertise over $204 million in collective investor interest. And now we're going to talk a little bit about federal regulation. So the reason that we hear so much about crowdfunding recently is that there have been federal regulations passed that would loosen up what were existing 80-year-old regulations on the crowdfunding world. So traditionally, securities that are sold privately, that is not on public markets, have been subject to particular restrictions under the 1933 Securities Act. And the Securities Act basically restricts the sale of securities unless they are subject to an available exemption from registration or if they are registered with the SEC. And none of these private companies register their securities with the SEC, so all investors who invest in them must be subject to some sort of valid exemption. The most well-known exemption is the Regulation D exemption for accredited investors. It provides that folks that are sufficiently financially sophisticated are eligible to invest in private securities. For anybody who hasn't heard of this before, an accredited investor is somebody whose net worth exceeds $1 million, excluding their primary residence, or who has an income that exceeds $200,000 and has the expectation for that same income over the next 2 years. You could have a jointly with your spouse $300,000 income that'll also qualify the two of you as accredited investors. So it's mostly this accredited investor status that renders individuals eligible to participate in equity crowdfunding. And of these companies that we showed you here, every single one of them for now is forced to restrict their sales to accredited investors. So you'll go through a questionnaire when you go through the intake process, and if you do not answer yes to a question that triggers that you are either earning $200,000 a year or $300,000 jointly with your spouse or have a net worth that exceeds $1 million, you won't be able to make it past the initial screen. You won't be approved, and you won't be able to participate in equity crowdfunding. So this brings us to the Jobs Act, which was signed into law on April 5th, 2012, and which has authorized the SEC to promulgate crowdfunding regulations that would particularly permit unaccredited investors, or the vast, vast majority of folks who are right now unable to invest in private placements, to authorize the SEC to issue rules that would provide for unaccredited equity crowdfunding. These rules have not been finalized yet, and we're not going to get too deep into what we think they might look like, but there have been proposed rules that have been put out by the SEC. They're a little bit dense, and we apologize for this particularly wordy slide. But effectively, on October 23rd, 2013, the SEC put out rules that would provide that unaccredited investors can invest in offerings of $1 million or less, and that's $1 million raised during any 12-month period. And then based on whether the individual's net worth or annual income was more or less than $100,000, that would govern the amount of money an individual can invest each year. An example here is if your net worth or annual income is less than $100,000, then you can invest the greater of $2,000 or 5% of your annual income or net worth. If your annual income is the larger of those two and it happens to be $100,000, then you can invest a total of $5,000 in equity crowdfunded startups that year. There are a handful of other requirements in the proposed legislation. That is that there must be that the sale must be distributed via either a broker-dealer or a crowdfunding portal. There are specific disclosure requirements that are not very different from disclosure requirements applicable to publicly offered securities. And there's a 1-year restriction on the sale of those securities unless they're sold to the public in a registered offering, to an accredited investor, or back to the company. And there is plenty out there on what people think of these requirements, and we really don't take any position on whether or not we think this is where they're likely to come out. And we think that maybe there's some more interesting things that are happening at the state level which are more relevant to social enterprise and impact-focused companies. But we want to just get out of the way so that there's no confusion. This is not valid law yet. The SEC has kicked the can down the road for a number of months, and we're waiting to see when they're going to finalize these rules and whether or not those rules are going to look at all like the ones that they've proposed, which are right here. And that brings us to state regulation. And I think Rob is going to talk a little bit about the states.
Right. So on the heels of the federal government and the SEC taking quite some time to finalize the equity crowdfunding regulations, a lot of states have decided that they are just going to go ahead and pass their own equity crowdfunding laws or regulations to provide this type of option for people that are operating crowdfunded equity crowdfunding campaigns on an intrastate basis. And I'll get a little bit into that some more in a few slides. But this big quote is from the preamble of the Washington Jobs Act of 2014, which just became effective last month. And I think that this encapsulates the rationale behind this, and I'll just read briefly from it. The Washington legislature found that startup companies play a critical role in creating new jobs and revenues, and crowdfunding allows smaller enterprises to access capital they need to get their businesses off the ground. The legislature further finds that the costs of state securities registration often outweigh the benefits to Washington startups seeking to make small securities offerings, and that the use of crowdfunding for business financing in Washington is significantly restricted by the state securities laws. Helping new businesses access equity crowdfunding within certain boundaries will democratize venture capital and facilitate investment by Washington residents in Washington startups while protecting consumers and investors. And that, in a nutshell, is the goal of a lot of these state equity crowdfunding laws that have recently been passed. A brief overview of some of the developments that have happened on the state level. As I said before, states have gone ahead and preempted the federal government and the SEC by adopting exemptions for intrastate equity crowdfunding campaigns that comply with the federal exemption for intrastate offerings. Essentially, Section 3A11 of the Securities Act of 1933 offers an exemption if you are offering your securities within a single state. And because of the Commerce Clause and a lot of constitutional law issues that we don't have time to get into now, the federal government does not have the authority to regulate intrastate, i.e. within a single state, private offerings, and the states therefore are free to develop and promulgate their own rules for these particular types of offerings. So you would need to be, for instance, a company that is organized under the laws of Wisconsin, that operates within Wisconsin, and that only offers securities to residents of Wisconsin. So some states, like Wisconsin, have gone ahead and just simply passed legislation that amends the existing securities laws. Other states have not gone through the legislature, but rather the state securities regulators have adopted new rules that provide exemptions for equity crowdfunding. This has happened in Georgia and Kansas. And it's happening in quite a lot of other states. In fact, 14 states already permit some form of equity crowdfunding, and many more are currently considering similar legislation, or are their state securities regulators are considering the adoption of new rules that would permit equity crowdfunding. So this is an area of law that is very much in flux, and as the next slide shows, there have been enacted exemptions or exemptions that are currently under consideration in a broad range of states from all parts of the country. And if you'd like some further information, the credit at the bottom, the crowdfundinglegalhub.com blog is very helpful and has some nice maps and charts. This map is as of July 2014, so it is pretty up to date. But again, this is an area that moves very quickly, and in another 3 months, this map will look much different than it does right now. So in any event, an area of a lot of action in the law right now at the state level. To try to dig a little bit deeper into the weeds here and draw on what Shawn was discussing earlier with the federal equity crowdfunding regulations, here are a few examples just to give the audience a sense of the variations from state to state as they continue to experiment with finding the right balance here. For example, in Wisconsin, the recently passed legislation would decrease the threshold for a certified investor, also known as an accredited investor, down to $750,000 of net worth or individual income exceeding $100,000 or $150,000 joint income with your spouse. If you will recall from a few slides ago, these numbers are markedly different from the federal proposals, which were $1 million and $200,000 and $300,000 for individual and joint income. And so this is seen as a way to further democratize access to state-level equity crowdfunding by opening it up to people who might otherwise not be able to claim accredited investor status. There are also issuer offering caps. In Wisconsin, the statute provides for a $1 million cap in a 12-month period if there is no financial audit provided, and a $2 million cap if there is a financial audit provided. It also has a 12-month period limit on how much non-accredited investors, so under the Wisconsin statute, these would be individuals with less than $750,000 in net worth or individual income of less than $100,000. For all of those individuals who would still like to participate in equity crowdfunding, they are permitted, but they can only invest up to $10,000 in any 12-month period. Another example, Michigan, which also recently passed equity crowdfunding legislation, it does not alter the definition of an accredited investor. It uses the Regulation D standard that Shawn described a few moments earlier, a higher standard, I would note, than the new Wisconsin statute. They have the same issuer total offering caps, so you can only at most raise $2 million as so long as you provide prospective purchasers with a financial audit. And again, they use the same $10,000 limit for non-accredited investors. In a slightly different path, the state of Washington has issued a total offering cap of $1 million across the board, and take a slightly different approach to the individual investor limits that are very much similar to the proposed limits under the federal Jobs Act regulations, which have yet to be finalized. And so just from looking at these three states, you can see that there is quite a bit of variation, that the state equity crowdfunding laws vary pretty considerably from state to state, and it's just something to be aware of if you are in fact interested in getting involved in this space. Which leads us to our conclusion, and I think we should have a few minutes left for some Q&A, but Shawn is going to wrap up, and we'll be happy to take your questions for as long as you'll have us.
Sure. So as I'm sure you can tell, we think crowdfunding, at least equity crowdfunding at the state level, is more interesting and is a better place for experimentation than at the federal level. It's happening more quickly, and we're going to see a bunch of different iterations, and we'll be able to test out which of those are effective and where they really find traction and where they don't. And we think that's fitting for social enterprise because social enterprise and social entrepreneurship is also something that's being simultaneously regulated on the state level via the benefit corporation and the flexible purpose corporation and the low profit limited liability companies. These are all state level entities, and we have similar maps to the one that we showed you before that illustrate the growth and the spread of legislation aimed at inducing social entrepreneurship. And I'm sure you could map those two on top of each other and find that there's a significant overlap between states that are experimenting with forms of innovative forms of social enterprise structuring and states that are experimenting with forms of crowdfunding. But we think for that reason, it's actually it's something that will happen in the most interesting ways at the state level, and it is suited for social enterprises because they're often much, much smaller, certainly much smaller than large publicly traded companies, but even on average much smaller than private companies that have no social enterprise. So we think that crowdfunding and social enterprise regulation at the state level, both in its structural regulation, that is the benefit corporation, and in its and in this new wave of state-level crowdfunding exemptions are really where the most interesting things are happening. One other item to note is that we suggest, and Rob and I have been talking a little bit about this in some of our other presentations, and we'll hopefully be building on this in future presentations or articles, that crowdfunding and the social impact bond space are a particularly interesting intersection, and that they are great for social entrepreneurs to be thinking about. The thinking there is that a lot of the concern over whether or not it's a good idea to let folks who are otherwise new to investing get involved in the investment landscape is that there's an enormous likelihood that they will lose their money. There's likelihood of fraud, there's a strong likelihood of failure among emerging companies, and what the regulations do via their reporting mechanisms is try and reduce that risk. And they also try and do this via the limitations on what an unaccredited investor can put at stake. They try and limit the amount of money that you can put to risk if you are new to investing effectively. So we think that this is slightly de-risked by the growth of social impact bonds, and that anybody who knows a thing or two about social impact bonds knows that they go through some sort of government vetting process, some sort of RFP that results in a selection process done at either the state or city level, and that process can serve as a great de-risking mechanism for retail investors to ultimately participate in. So whereas existing social impact bonds have mostly targeted private wealth clients of large banks or the large banks themselves, and in some cases have been backstopped or aided by private foundations, we believe that retail investors who are thinking about getting involved in crowdfunding would be best served by starting off in the social impact bond space, where there are greater checks on the investment and where they can still have the sort of impact that they might want to have in the traditional social impact space. There's one example that we cited last time, which was the Essex social impact bond, the Alia Future for Children bond in England, where retail investors were permitted to invest. We want to see more things like that. I think it'd be very interesting, and it can really only happen at the state level because the federal regulations out there aren't yet promulgated. More importantly, because social impact bonds really happen at the state level, and that's where this sort of activity is going to happen. So that is about all we've got for today. We've still got about 5 minutes, but as Rob said, we'll take questions for as long as there are any. And thank you for joining us.
Thanks, Shawn. Thanks, Rob. Very informative as always. That was a great presentation. I haven't seen any questions come in, folks. We'll wait maybe 30 seconds or so more. Take advantage of these two guys. Obviously, they're very knowledgeable, and they only you will be here for a few more minutes to answer questions. So submit now.
Apparently, we were very informative.
Looks like you covered the entire topic so thoroughly that we don't have any questions. So once again, Rob, Shawn, thanks as always. This was a great session. We're certainly going to be doing this again, folks, so we encourage you to join us for our 4th webinar in this series. Public Allies, Mac Antigua, thank you so much for helping us develop these and put this together. And
yeah,
thank you all in the audience for joining us. Mac, do you have anything to add?
I would just say it's been great working with these guys, and I mean I look forward to the next jam. And I mean I think for our network this is a very fascinating one. I think a lot of people kind of might have from my network might have come like, how do I do this better? Like I want to make some money now, right? But there's a lot of nuance here, right? And there's still a lot of terrain to be covered. And so it seems like if we come back in a year, right, Shawn and Robert, you might have a whole different presentation because there's a lot of stuff that's moving pretty fast.
Oh, that's right. Within 6 months, we're thinking that this will look different.
Yeah, so I mean, it's almost like stay tuned. We look forward to checking back maybe in 6 months as this terrain changes.
We are looking forward to it too.
All right.
All right. Well, thanks so much, folks, and thanks to all of you for joining. Please fill out that survey. It's coming at you right when you leave the webinar. And until next time, take care.